Hi, I'm Jeff Antonelli, founder of Antonelli Law Firm. Our focus is on digital copyright infringement cases, including claims involving illegal streaming of pay-per-view events, unauthorized downloading of software, and sharing movies through BitTorrent. We've been defending clients accused of online copyright infringement since 2011, starting near the inception of these lawsuits. Over the years, we've successfully assisted more than 6,000 clients nationwide, navigating cases brought by over 50 different companies, employing a wide range of defense strategies, and with our extensive experience and proven legal experience in this area of law, we understand how to reduce risks and minimize costs for our clients while effectively resolving their cases. Have you recently received a notice from your internet service provider about a subpoena from Strikethrough Holdings, LLC? Don't worry, you're not alone. They are one of the most prolific filers of this type of lawsuit. Today, I want to walk you through what this notice means, why you have received it, and how we can help you navigate this situation. Let's start with the basics. Strikethrough Holdings, LLC is a company that produces adult films under subscription sites such as Slade, Blacked, Vixen, MILF, and Tushy. They are very aggressive about protecting their copyrights, and they use advanced tracking software to monitor what they say are illegal downloads through the BitTorrent file sharing system. You received your notice because they have allegedly tracked illegal downloads of their films to your IP address. They have filed a lawsuit in federal court and issued a subpoena to your internet service provider asking for the name and contact information associated with that IP address. Strikethrough Holdings claims they're pursuing these claims to protect their copyrights, but many people see this as a way to pressure or embarrass individuals into settling out of court. When you receive a notice from your internet service provider, it means they've been asked to provide your personal information to Strikethrough, and they're letting you know before they do so. You typically have around 30 days from the time you receive the letter to decide how you want to handle it. Let's talk about your options. There are several ways to handle this situation. The first option is to ignore the notice. Right now, the court only knows you as John Doe. If you ignore the subpoena, your internet service provider will give Strikethrough Holdings your name. Once they have your name, two things could happen. Number one, the case might be dismissed without prejudice. This means the case is paused for now, but could be brought back later, although we aren't aware of this happening. Typically, we've seen the cases marked dismissed in the court docket about 60 days after people received the notice when they ignored it. Number two, they could file a new complaint with your real name, called an amended complaint. At that point, you'll be served with a court summons, which you cannot ignore. Starting in about 2021, we noticed that in every Strikethrough Holdings case, the court started allowing your name to stay private by filing under seal, so only a redacted version is public. This means that even though Strikethrough has your name and has served you with a summons, your name is still not public. However, your name may become public sooner or later, either if you choose to fight the case or if you fail to respond in time and the court allows a default judgment to be entered against you. If keeping your name private is essential, contact us so we can help. Because of this new development, it may seem like you might as well ignore Strikethrough Holdings since you can still settle if you get a summons. Here's what to know about receiving a summons. If you ignore the subpoena and do get served with a summons, you'll have less time to respond, fewer options, and less power to negotiate. It may also make things more stressful to deal with. In addition, what we've seen recently is that if you wait until you receive a summons, the settlement amount requested at this stage tends to be much higher. For example, a recent case we worked with initially asked for $750 per movie, but after being served a summons, the demand had increased to $1,500 per movie. If you decide to ignore the notice and receive a summons, remember, never ever ignore a court summons. If you do, the court could automatically rule against you, which could cost you a lot of money. We've seen cases dismissed for some people and pursued for others, but there isn't always a clear reason why. Anyone can be pursued, no matter their financial situation. However, if you do have assets, it does appear to be more likely that strike-through holdings will pursue the case against you. The second option is to settle the case out of court. Settling can be a way to resolve the matter quickly and discreetly, but it's important to approach this case carefully. At Antonelli Law, we can negotiate directly with strike-through holdings on your behalf. Our goal is to secure the best possible outcome for you, including aggressively working to reduce the settlement amount, working to ensure the terms of the agreement protect you from any other downloads being alleged after the lawsuit was filed until the day you obtain a settlement agreement, and of course to protect your privacy. Settlement with a company like Strike3 is both art and science. We've worked tirelessly over the years to figure out the most aggressive and smart settlement tactics, not just for strike-through holdings, but for all of the 50 companies and more that we've defended people against. If you decide to settle, our goal is to get you the best deal and protect you as much as possible. The initial settlement demands from the movie company start at $750 per alleged movie download. That figure comes from the Copyright Act as the minimum statutory minimum damages that a federal court would have to award the movie company, plus reasonable attorney's fees and costs if the case went to court and resulted in a judgment in favor of Strike-Through Holdings LLC. Actual settlements vary quite a lot. Oftentimes, the settlement in a particular case may depend on a variety of factors, but most often are centered on the general financial circumstances of the parties seeking to settle with the movie company, including whether some or all of the income or assets are legally protected from potential garnishments. Other factors include the number of alleged movie downloads. Please note that internet chatter about this appears to be very overblown, and I fear many people can be misled by focusing on this number. Here's why. For example, two people with similar, relatively poor financial conditions may pay similar amounts to settle, even though one person was alleged to have downloaded around 30 movies, while the other was alleged to have downloaded, say, 75 or more movies. The quote, average cost to settle per movie can be wildly different, but the settlement amounts are almost the same. If the first person with 30 alleged downloads settles for $2,500, that would be $83 per movie. While the second person with 75 alleged downloads, that's about $33 per movie. Both people are paying the same amount to settle the Strike-Through Holdings lawsuit, and both people have the same limited financial means. The burden to each of them is the same. Now, another pair of people with somewhat better and similar financial circumstances to each other would probably have similar results. The settlement cost for both of them can be the same but higher for both. Let's say the first person settles for $7,500 with 30 alleged movies. That's $250 per alleged movie download. And the second person also settles for $7,500 but for 75 movies, and that comes out to $100 per alleged movie download. Again, they're paying the same amount of money to settle. They both have similar financial circumstances, and the burden to each of them is the same. Finally, there are other factors involved that can have a material effect on the price of a settlement for a Strike-Through Holdings lawsuit. Many of these have come from my experience in the courtroom that occurred long before Strike-Through Holdings ever existed, as well as helping thousands of clients nationwide against all kinds of movie companies alleging BitTorrent copyright infringement. We aren't going to publish our secret sauce, but one general factor I will discuss is the question of evidentiary circumstances that a jury may conclude tells them the defendant could not be responsible. Because, for example, the defendant was on a work trip or a pleasure cruise far away for, say, 30% of the dates of the alleged downloads. The third option is to fight the case in court. This might be the right choice if you believe you haven't done anything wrong, or if you want to challenge Strike-Through Holdings' claims. We have extensive experience litigating these cases, and we'll build a strong defense based on the details of your situation. We'll also work to protect your identity and privacy throughout the process, because we understand how sensitive these cases can be. This is rarely an option for strike-through holdings cases, but can work on occasion. A motion to quash is a request of the court to invalidate the subpoena that was issued because it was issued for flawed reasons. This will prevent your personal information from being disclosed from your ISP to strike-three's attorneys and stops the lawsuit from moving forward. Motions to quash only work in limited circumstances. And even if you win your motion, strike-three could potentially amend the complaint and re-subpoena your ISP. We have won motions to quash against movie company lawsuits in the past and can tell you if you're a candidate during our consultation. Many of our clients have done a deep dive on online forums before the consultation, so we tend to get a lot of the same questions. Some things the forums get right, and some things they get very wrong. Here are some of the most common questions we get based off online forum posts. First, we pride ourselves in providing information to our clients so they can make the best decision for themselves, whether it's settling or not. Our team has years of experience handling these specific cases, so we understand the tactics employed by strike-through holdings and other movie companies and how to respond effectively. We've helped our clients settle, defend themselves in court, get the case dismissed, and file successful motions to quash. During our initial free consultation, we'll carefully review the details of your case, answer your questions, and lay out all of your options. We can provide customized legal strategies that align with your goals, whether that means fighting the claim, negotiating a favorable settlement, or some other legal action. With over a decade experience in copyright law and having represented thousands of clients over against 50 different companies, we are well equipped to navigate all aspects of these cases. Our team isn't here to push you towards a settlement. We're here to defend your rights and explore all viable options so that you can make the right choice for yourself. Deciding to ignore a legal case without any details because of something you found online isn't a great idea. Make sure you speak to an experienced BitTorrent defense attorney to understand all your options before you make the decision to just ignore it. So you understand what you're facing and what the typical cadence of these cases are like, and that you feel confident that you're making the best decision for you. This seems to be a very common misunderstanding. You don't get second chances at the subpoena. These cases tend to follow a specific pattern. Very simply, first, you get notified that your details are being requested. The subpoena has already gone to your internet provider. Second, if you do nothing, strike three gets your details. And third, strike three decides what they want to do next. Fourth, you get a summons or the case gets dismissed. Reaching out ahead of time ensures you of being anonymous to the public and can make the settlement lower. However, it also means you're definitely going to have to pay them. If you ignore this, Strike-through Holdings is going to get your details, so now you have to decide if you want to gamble on the case getting dismissed or not. Reaching out to settle does not put a target on your head. As we just mentioned, if you've already decided to wait until after the deadline in the ISP letter, they already have your personal details. The question will be whether you receive a summons or they dismiss the case. So this comes down to your tolerance for risk. Subpoenas and their notices are going to be mailed to you. They're not paying private detectives to serve you in person, and it's not difficult to serve you with an ISP notice and subpoena. First, you are not being subpoenaed. Your ISP is. Your first notice is your ISP letting you know that Strike 3 subpoenaed them. They're just sending you the notice, usually via UPS or FedEx, sometimes by US mail, and sometimes mail and private courier. ISPs also sometimes use email, including AT&T. Once your ISP hands over your details, the movie company and their lawyers will decide whether or not to have a process server find you and physically hand you a summons. This is a specialized area of law. and there can be potentially serious financial implications for these cases. Just like you wouldn't use a personal injury attorney in a divorce case, we recommend you work with an attorney that's experienced with BitTorrent copyright defense. Since copyright cases happen in federal court, we can represent you no matter where you are in the United States. We have represented clients nationwide for over a decade. When a patient has a serious or perplexing medical condition, many people will look out of state to be seen by top specialists. For regular checkups, their generalist doctor at home will be just fine. Antonelli Law has dealt with federal BitTorrent lawsuits, both in and out of court, for thousands of clients across the country. Quote, "You should refuse to settle," is what some people think they should do. This is the same thing in the court's eyes as ignoring it. In this instance, you could get served with a summons. If you ignore your summons, you will likely get a default judgment entered against you in court. You can absolutely take these cases to court, but unfortunately, this is a civil matter, so you don't qualify for a public defender in this type of a lawsuit. We've seen depositions happen in the Maryland District Court, even prior to being served with a summons. Typically, the process for this is that you'll be commanded to attend a 1-hour deposition after you receive the notice from your internet provider. If you decide to fight the case in court, you will almost certainly have to attend a regular deposition during what's called the discovery phase of a lawsuit. That's normal for almost all lawsuits of any kind. Being trained litigators, one of our aims in defending a case in court is to find fatal flaws with the other side's expert witnesses or their evidence and persuade the court to ban them from being allowed into evidence at trial. If that happens, their case falls apart and we feel like heroes. So yes, you can take the case to court to challenge the validity of their evidence. However, that means you still need to go to court. Again, this comes down to your tolerance for risk. We obviously don't know why some companies protect their intellectual property more vigorously than others. We do know Strike 3 is currently the most prolific filer of these types of lawsuits. However, in a recent court filing, Strike 3 noted that the monetary gains from these lawsuits are only a small fraction of their total revenue. It's important for you to know that while your timeline and options are a little more limited, you do still have options and the ability to negotiate. This is definitely the time to schedule an appointment so we can discuss your case and work to get you the best possible outcome. During your free, confidential consultation, we talk about your situation, explain what the notice means, and discuss the potential outcomes. This isn't a one-size-fits-all conversation. Every case is different, so we'll look up your specific case details, take the time to listen to your concerns, and provide advice that's tailored specifically for you. Many consultations are at least 30 minutes, and sometimes consultations with the firm's founder, me, Jeffrey Antonelli, may last an hour or more if necessary. Your consultation will be private, judgment-free, and completely confidential. Some of the things we will cover include what your notice means, what options are still open to you, how much each option is likely to cost, and the typical settlement amounts based on your specific lawsuit. What to expect if you go to court and any other questions that concern you. We also want to make sure you avoid common mistakes that could hurt your case. For example, don't sign anything or agree to a settlement without speaking to an attorney first. Don't delete any files or make changes to your devices. This could be seen as destroying evidence and might work against you if you decide to go to court. Hiring Antonelli Law to help you with your Strike 3 Holdings case can make all the difference in the outcome. If you do want to settle, we know the best settlement deals can heavily rely on timing. We will double check specific facts on your subpoena to give you a stronger negotiating position. We know which documents and information to send based on individual statutes for the best leverage. We have gotten cases dismissed, and we can cover many of these items during your consultation so that you can be confident in your decision on how you want to handle your case. At Antonelli Law, we understand that receiving this kind of notice can feel like your life has been turned upside down. But the good news is you don't have to do it alone. Our team has the experience, knowledge, and compassion to help you through this process. We've helped countless clients resolve their strike-through holdings cases, and we're ready to help you too. Contact us for a confidential consultation to get clear professional advice about your options. We'll explain everything in plain language and help you figure out the best path forward.